Don't let them take your home. If you're in foreclosure and you've already obtained a temporary restraining order, first, let me congratulate you. That means you've acted before it was too late. It means the court believed there were enough questions about the foreclosure to press the pause button. But here's the mistake many homeowners make. They think the fight is over. In reality, the TRO is just the beginning. The foreclosing party is already preparing its response. Its lawyers are looking for a way to convince the judge to dissolve the TRO and let the foreclosure sale go forward. The next battle is often the most important one you'll fight. It's called the Preliminary Injunction hearing. Today, I want to explain what the hearing is really about, why it matters, and why homeowners who understand this process are in a much stronger position than those who don't. The first thing to understand is that a temporary restraining order is exactly what the name suggests. It's temporary. The judge isn't deciding who wins the case. The judge is saying, I need more time before I allow something irreversible to happen. A foreclosure sale is one of those irreversible events. Once your home is sold, the legal landscape changes dramatically. Someone else may claim ownership. A trustee's deed may be recorded, and eviction may begin. New legal issues arise that never existed before the sale. The law has recognized for generations that it is far easier to preserve someone's rights than it is to restore those rights after they've already been taken away. That's why preliminary injunctions exist. A preliminary injunction is not about delaying justice. It is about making sure justice happens before the property changes hands forever. Now, let me tell you where we've seen many homeowners and unfortunately many lawyers go wrong. They spend enormous amounts of time arguing that the bank committed fraud. Maybe it did, maybe it didn't. But that's not usually the first question a judge wants answered at an injunction hearing. The first question is much simpler. Does the party asking to foreclose actually have the legal right to do it? That question is called legal standing. Standing is one of the most powerful issues in foreclosure litigation because it goes to the heart of the case. It's what we use most predominantly here at Living Lies. If the plaintiff cannot establish standing, then everything that follows becomes questionable. Who owns the debt? Who has the authority to enforce it? Who instructed the servicer to foreclose? Who actually suffered a financial loss? These aren't technical questions. They're the questions every judge should ask before allowing someone's home to be sold. Over the years, one of the biggest challenges in foreclosure litigation has been the complexity of modern mortgage finance or securitization. 30 or 40 years ago, these cases were relatively straightforward. You borrowed money from the local bank. The bank usually kept the loan. If you defaulted, the same bank brought the foreclosure. Today, that's rarely what happens. Instead, loans are pooled into securitized trust. Servicing rights are sold. Sub-servicers become involved. Master servicers oversee the process. Trustees represent investment trusts. Document custodians hold original notes. Nominees appear in public records. By the time the foreclosure begins, half a dozen different companies may appear in the paperwork. Each one claims some form of authority. But claiming authority is not the same thing as proving authority. And that's where preliminary injunctions become incredibly important. One of the things we've emphasized for years at Living Lies is that labels don't prove anything. A company can call itself a trustee. A company can call itself a beneficiary. A company can call itself a servicer. Those titles don't answer the real question. Where's the evidence? Who granted that authority? When was it granted? Does it include the right to foreclose? Can the witness explain it under oath? These are the questions that matter. Now let me talk about something that has become one of the most valuable tools we have available today, loan level data. This is one of the reasons Living Lies has invested so much time and effort developing the ability to obtain and access and analyze loan level data information. We have proprietary loan level data access superior to others purporting to be able to give forensic loan audits. We've investigated many of them and they mostly appear worthless in front of a judge. Our loan level data is important because it tells a very different story than the foreclosure complaint. It may identify the investor, it may identify servicing transfers, it may identify ownership fields, It may identify reporting information that never appears in the county records. Sometimes that information supports the foreclosure. Sometimes it raises serious questions. Either way, it gives the court a much clearer picture of what actually happened. And that's exactly what an injunction hearing is supposed to accomplish. Quiet title issues also become important if multiple parties claim rights against the property, if assignments appear years after the alleged transfer, if ownership records conflict, if different entities identify themselves as the beneficiary, or if the beneficiary claiming the right to foreclose isn't even showing up in the chain of title. Should the court allow the property to be sold before these issues are resolved? We don't think so. Neither do many judges. The purpose of preserving the status quo is to allow those disputes to be examined before permanent consequences occur. One of the reasons preliminary injunctions make foreclosing parties uncomfortable is that discovery usually follows. Now, documents must be produced, witnesses may be deposed, servicing agreements may be requested, pooling and servicing agreements may become relevant, internal servicing notes are important, boarding records, communications between servicers, authority agreements, investor reports, and perhaps most importantly, loan level data. Discovery replaces assumptions with evidence. That's exactly why injunctions matter. Now let's talk about timing. If you're in states like California, Texas, Georgia, Arizona, or any other non-judicial foreclosure state, you simply don't have the luxury of waiting. Don't wait. Non-judicial foreclosure moves quickly. By the time many homeowners decide to act, they're only days away from a trustee's sale. That is the worst possible time to begin gathering evidence. The best time is as soon as you receive notice that foreclosure is being pursued. Because once the evidence is organized, once the standing issues are identified, once the loan level data has been analyzed, you place yourself in a much stronger position to ask the court to preserve your rights. Living Lies and our team here has spent more than 2 decades building resources for homeowners and lawyers that go far beyond legal arguments alone. We help identify the actual creditor through loan level data. We prepare qualified written requests and requests for information designed to obtain documents the servicer would rather not produce. You won't find our QWRs on the internet. We assist attorneys with discovery strategy. We prepare expert affidavits. We provide expert witness testimony, and we help connect the financial transactions to the legal documents so courts receive a complete picture instead of isolated pieces of paper. Because when the courts have the complete picture, the outcome often changes. Here's what we want you to take away from this video. If your foreclosure sale has already been scheduled, don't assume you're out of options. If you've obtained a TRO, don't assume that work is finished. A preliminary injunction may be the most important hearing in your entire case. It gives you the opportunity to replace assumptions with evidence, to replace labels with proof, and to require the party seeking to take your home to establish that it actually possesses the legal right to do so. That's what due process requires, and that's exactly what we work every day to help homeowners and their attorneys accomplish here at Living Lies, Defend the Foreclosure. If you'd like us, Living Lies, defendtheforeclosure.com, to help analyze your case, review your loan level data, identify the actual creditor, or assist your attorney with expert litigation support, visit defendtheforeclosure.com, where we say, your home is your castle, we help you defend it. Learn more at the link in the comments.